Let me get this straight. You blew up a building.
2 CIs and the CEO of 22andU.
Two competing federal agencies with the same mission.
I don't understand why those Fed a-holes are so darn mean.
To protect the public from the scourge of dangerous misinformation.
You know those bum idiots. This is all them. We had a solid case.
The word entrapment, not even in their vocabulary.
The explosives we provided were fake.
Sworn to a duty to always tell the truth.
We have no indication at this time that this was a deliberate act.
We're all being transferred.
To where?
The only place currently with openings. Alaska.
Good morning.
Welcome to the office, huh?
And we got the retro feel. You know, the funny about federal buildings, they're all different, but they're still somehow all the same.
Oh, good morning, Agent Walker. At the coffee station. We actually drew straws before he got here, and I won, so we get to work together.
Let's get started. Let's see if we can't stir something up.
Let's give it a minute. I like to warm up my truth muscles a little coffee beforehand.
Well, what do you want to do first?
What do we have for a surveillance van?
Oh, wow. I got a Ford Explorer. We don't have a surveillance van.
Do you put many cases here?
Cases?
Yeah, cases. We're the tip of the spear when it comes to protecting American democracy.
You really believe this? You really believe that people posting crap online is going to cause our country to crumble?
I think the work that we do is important.
We don't have a surveillance van.
Me and some people got one. We've never needed one.
We need a surveillance van. We need a big case or a CI who can lead us to a big case.
What do you need the van for?
Surveillance.
CIs, or confidential informants, are the lifeblood of any good law enforcement agency. Public posts on social media are one of the best ways to find CIs. Agents would never use coercion or take things out of context to try and persuade someone to become a confidential informant.
The new Taylor Swift single is absolute fire. I'm just seeing a lot of incendiary and violent language here.
Agents always need to be on their toes and ready to make snap decisions.
Is there anything I can do for you guys? Actually, David, there is something you can do for us.
Chicken nuggies.
Chicken nuggies.
What?
Cheeseburger.
Cheeseburger. McDonald's cheeseburger.
Burger King.
Burger King cheeseburger.
Flame broiled.
Chicken nuggies.
Oh, baby, know you're gonna like it. I wanna be your beaver pilot. Said, honey, know you're gonna like it. I wanna be.
Awesome, right?
Is this a loner?
This thing's totally legit.
What is this? It's got windows!
I need to
I really don't see what the problem is with the windows in the van.
I don't either.
We
I
have
need to put
doggo
a
today.
timer on that thing. I need to put a timer on that thing so I know when it's going to end, because it's always a guess. It's really long. That like and subscribe thing at the end there. I never know
talking about the trailer itself.
Oh well, no, I could do the whole trailer, but
Yeah, you're dropping all the one-liners in one trailer.
Oh, there's plenty more.
Who do we have today? What
do you got going on, Mr. Michael? How are you?
Not a lot. It's been a day with a Wednesday at that, so those could be fun. Today wasn't, but I see the dog's excited.
Oh yeah, nope. That's the excited doggo cam.
Yeah.
They don't. There's not much action there.
Yeah, probably not. I got a cat that does something similar.
Mm-hmm. They do. They lay around a lot.
Yeah,
especially as they're getting older.
Yeah, especially the older ones. It went from sleeping 20 hours a day to sleeping 27 hours a day.
Oh, wow. Yeah. Yeah, no, exactly. Well, shoot. It was there's a little more action in the case today. But there was also just a whole lot of what in the hell is going on, which is kind of the same thing, I guess.
I'm about to say that sounds par for the course for this one.
Oh yeah, no, it's it's crazy. All right, so let me share my screen. Let's just dive into it. And
Yes.
hi, everybody. Oh no, I did not see your tweet earlier. Let's look that up, shall we? While we got a moment, let's go ahead and share this. Oh, actually,
Hello, Robbie.
I'll hide it for a second. Hello. All right, give me a second here.
So not much for exciting, just
Oh no, there was some interesting legal arguments going on today.
Ooh, my favorite.
Yeah, no, there was some interesting legal arguments, and then there was like a couple of the different folks who covered the trial. It looked at it completely different. They had completely different takes on it at the end.
New strategies.
Kind of thing here. So, but yeah, Patty's, I like that. She says, I knew Brenner reminded me of somebody who was equally punchable as a sniveling, whiny fink face. And my brain subconsciously knew it by providing me the fink face descriptor.
Major Burns.
Major Burns. Oh, yeah. I love MASH. I'll be right back. I realized I didn't open my window. Started to get a little hot here. But yeah, MASH was
I loved how the U.S. active involvement in the Korean conflict was 3 years, 50 to 53, and MASH lasted for 11 seasons.
Well,
Hollywood math.
The show was more interesting than the war, I guess.
Yeah, I like how Klinger many times was seen wearing his Toledo Mud Hens hat.
Mm-hmm. Oh yeah, definitely. All right, so let's see. Okay, so we started off today with a trooper.
All right, witness 22, let's go.
This is one of the young troopers.
All right, Mr. Brennan, whenever you're ready.
Thank you, Your Honor. Good morning. Good morning, sir. Could you please introduce yourself to the jury, spell your last name for the record?
Sure, man.
And I think what they're trying to do is they don't want to bring on Trooper Proctor. Now, tomorrow they're supposed to bring on Buchanan, right? Which is like the supervisor. But, Proctor you knew Proctor got fired, right? Did you hear this?
No.
Yes.
Michael
Proctor. Yes, Michael Proctor is no longer a Massachusetts State Police officer. He has been fired. Most of what he got fired for was the results of this case.
Because of the failure of a prosecution?
No,
or the failure of police work.
Yes, the failure of the police work, the unprofessional text messages about the case, the revealing stuff about the case.
Gotcha.
Let's see. Well,
who's our Brady list candidate today?
I did get fired. We'll look it up on Grok.
Nice.
So he was fired due to unprofessional conduct during his role as the lead investigator in the Karen murder case. Massachusetts State Police Trial Board found him guilty of 3 charges of unsatisfactory performance, 1 charge related to consuming alcohol while on duty. So while he was on the stand, looking at Patty's thing. Yes, that's what I mean. while he was on the stand, he admitted to drinking while coming back from something. He had somebody else with him. He had Kevin Albert with him, actually. So, one of the Albert brothers. So they had gone there. They stopped. They got drunk. Kevin Albert lost his car. Specifically, Proctor sent so unsatisfactory performance. One charge related to consuming alcohol on duty. 3 charges of unsatisfactory performance. Guys, that's hard to say. Proctor sent derogatory, defamatory, and inappropriate text message about Karen Reed to family, friends, and colleagues, which included vulgar and biased marks. And he consumed alcohol. So he got fired. So they don't want to bring him up, right?
I'm going to assume since he was on duty, he also had all his work tools with him, such like his firearm that he's consuming alcohol with.
Well, on the last trial, it came out that Kevin Albert texted him and said, "Hey, did you find my gun in your car? Because I was too drunk and lost it."
Nice.
Yeah, right.
Yes.
Kevin Albert didn't get fired. He just got
professionalism prevails.
Suspended for a few weeks. So we get the young trooper. Let me get Trooper Duty back here. So we're putting young trooper on the stand first today. Share this tab. And I'm glad you're here. So you remind me, if I don't share a tab, let me know real quick. I'm trying to be mindful to share my tabs.
Connor Keefe.
Got it.
The last name is Keefe. Mr. Keefe, where do you work?
Connor Keefe comes in.
I work for the Massachusetts State Police. What's your position?
So they're going to basically Connor's coming in to introduce some evidence. He's going to introduce the shoe. Let's see if we can get there.
Yes.
So there's the picture of the shoe.
Yes.
There's a shoe in that picture?
Yes, sir.
Yes, there is.
Okay.
So now, of course, we go through the theater of him putting on a pair of gloves so he can then dig into the evidence box. So there you go. So
you do that to memorialize the date, time when the evidence was collected. Could you open the bag and show?
So yesterday, of course, we got the Stop and Shop bags with the bloody cups, the red Solo cups with blood filling in them. And there was a good moment on Cross yesterday where, because the Gallagher, the police officer, came in and went through this whole theater again of, putting on gloves and opening the box with the red tape and everything, and even asking him about why do you use the tape to tape it up, and he's like, because of custody and everything. So then they get on Cross, and Jackson is like showing him the picture of this open bag of bloody cups that they're going, where's the evidence tape on this? Is this sealed? Are these cups sealed? No. Is there evidence tape on this bag? No. It's just, what are you guys doing? This freaking kabuki theater of freaking evidence handling. All right, so she gets the shoe out. Let's see. I'll speed this up a little bit. And then we'll just skip. Cutting the tape with the scissors.
Whenever they open an evidence bag, they're going to put these on. And they're going to show things like the Statue of Liberty and just show it to the entire courtroom. All right. This is an example of that. I foresee us having a lot of this today.
Wow, it's a shoe.
That is a shoe. This is, you remember, this always reminds me of the OJ trial. I said this yesterday too. You remember the OJ trial with Darden showing off the gloves and everything,
right?
And the whole, showing it off, moving it around. This every time they do this, like Vanna White.
Is that the same item that you found that night?
Yes, sir.
If you could place it back in the bag.
All right, so he basically gets in, but we do find out something interesting from him, and I think he gets some. He gets to introduce some of the taillight pieces. Cut.
Here we go. Incoming to down moment. Our first pieces of taillight. First time the
Taillights.
jury's seeing it.
Look, I got taillights. Ooh.
I collect them from another car in the parking lot, but they're taillight pieces.
Yeah.
Sir, on those items that
Exactly.
are stickers, did you put the stickers on them?
I did not.
Do you know where the stickers come from?
I do not.
Do you know?
Well, this one says made in Bangladesh, and
I don't think that went the way the prosecutor thought it was going to go.
never ask a question that you don't know the answer to.
The stickers come
Yes.
from?
I do not.
Do you know if these items are ever sent to anybody other than your evidence locker? Are they ever removed and given to lab personnel and technicians?
Yes.
Do you know if that was done in this case?
Yes, I do.
Inside that bag, is there just 2 pieces or is there another piece in that bag?
There was another piece in the bag.
When you put the taillight pieces in that bag, how many pieces did you put in the bag?
I put 2.
Do you know if the other piece in the bag is a piece that broke off? Do you know how that arrived there?
I do not.
Could you just pull out?
Do you think that went the way it's supposed to?
Well, he knew to ask that question. Is this cross or direct?
This is direct.
Yeah, so
This is the prosecutor.
he was aware of the third piece. Okay. Yeah.
Maybe he was. I don't know that he
How
was.
that arrived there? Do you know if you put the taillight pieces in that bag, how many pieces did you put in the bag?
I put 2.
Do you know if the other piece in the bag is a piece that broke off? Do you know how that arrived there?
I do not.
Could you just pull out that other small piece and show the jury as well?
He's got to move it around. What in the world?
How much stuff is in this
going on?
bag?
Hey. That's not a piece. That's not red. That's somebody was saying
That's a shard.
okay, this is what I caught earlier. Somebody's saying that's a refractor. Right? So it helps shine the light where it needs to go.
Tiny piece.
So that's what somebody
They found
was
that in the
talking
snow.
about. Oh, maybe it is red though, isn't it? Yeah, you can see it's red there.
It's tiny,
Kinda.
tiny
Is
piece.
that smaller piece consistent with the same color as the 2 bigger pieces?
Yes.
Is it consistent with the same material?
Yes.
So yeah, it probably broke off, but it's still not a great look for the jury. Oh my gosh. All right, so then we go through. This guy is like, okay, but then we find out. Let's go. That
longer than
so Yannetti gets up to cross. So
Bob long.
Could have. He'd been on the job long.
so they're talking about the experience of between him and Trooper
don't recall.
Proctor.
Were you one of the newer members of the unit?
As of January of 2022?
Yes.
Yes.
Let's speed this up a little bit.
Trooper Michael Proctor had more.
Did you notice that? Trooper Proctor.
Yeah.
Then Trooper Proctor.
I'm curious if Trooper Proctor had his law enforcement certification or certificate taken, because if he was able to maintain that, he could just go to any other police agency and get a
Right.
job as a cop.
Yeah. Hey, can you do me a favor?
Yeah.
On the voice meter, there's a dial that says gain. Turn that off, or gate. Turn your gate off. You're crumbling up occasionally, and it's bugging me. Do you see that dial on the very first?
Yeah, turn to 0.
Yep,
that
turn
better?
it to 0. We'll see.
Okay.
If not, I'll have to mess with it later.
Time will tell. All right.
Yeah, exactly.
Trooper Michael
better so
then
far.
Trooper Michael Proctor had more
Then Trooper Michael Proctor. So
experience than you did as of January 29th of 2022, correct?
He could have. He'd been on the job longer.
Okay, well, if he had been on the job longer, then certainly that means that he did have more experience, correct?
It depends.
what do you think the jury thinks of that answer? Is like just you're being a smart ass?
Yeah. Wow, no, it's like he's answering the question, but he doesn't know the answer. So he's just maybe not. Who knows? Better question for him.
Like, who has more? Well, he would know who has more experience, though.
Mm-hmm.
If he's been on the team in a shorter amount of time, I think he's just being indignant. So this is what we find out, that they send the most junior member to the autopsy.
January 31st of 2022. And with regard to other members of your unit, you were the only one to attend that autopsy?
Yes.
That was done at the medical examiner's office?
The medical examiner's office in Sandwich, Massachusetts.
In Sandwich, Mass. And it was Dr. Irene Scordi-Bello who performed the autopsy, correct?
Yes.
Had you met her prior to that day?
No.
Had you spoken to her prior to that day?
No.
Did you know before the autopsy was performed that your former colleague, lead investigator Michael...
Your former colleague, I love it. He keeps it because it's not really come out that he's been fired. I don't think it's been said per se he's been fired. So they're doing everything they can to get it.
Make sure it comes up.
Yeah, exactly.
Proctor had discussed the case with Dr. Scordi-Bello without telling us what you knew of what was said.
Objection.
With regard to Dr. Scordi-Bello's knowledge.
All right. So they go back and forth about the autopsy and everything.
Yeah. Dead guy.
Yeah. Yep. Did they find out this is the first time?
Yes. Now, was this the first autopsy that you had attended, or had you attended ones in the past?
I cannot recall.
It could have been the first one?
You don't recall if you were in a room watching a dead guy get operated on.
When you're attending an autopsy as a member of the CPAC unit or the Norfolk Detectives unit, you are expecting that the medical examiner is going to examine the body, correct?
Yes.
And you're there to witness that examination, correct?
Yes.
At the end of the examination, you are expecting that there will be a determination as to cause and manner of.
So this kind of gets in the weeds. I don't think.
Yeah. They tend to wait on toxicology and stuff like that.
Yeah, they're not going to make a determination right there. Right.
Unless it's obvious. Yeah. I mean, unless you got, like a gunshot wound to the head or something like that.
Right.
You're just like, oh, he died of a heart attack. Well, you think it was a gunshot,
Yeah, this person's got a giant hole in their chest. I think that is probably the reason why they died.
Might be a contributing factor.
Yes.
Could have been athlete's foot.
So we find out.
The gentleman on the stand was the only one to attend the autopsy in Sandwich, Massachusetts, alongside with the medical examiner who performed.
All right. So next is the witness that takes up the rest of the freaking day. And that is Jessica Hyde. I'll share this. This is Jessica Hyde. This is the second iPhone expert witness to talk about the searches, the 227 search specifically, right? The how long would die in cold.
Is she Russian Orthodox?
I don't know.
You don't really see a lot of bonnets,
Right. Man, your mic is still doing that thing. I don't know why. We'll fix it later. I'll come in tomorrow. We'll fix it tomorrow. I mean, it's not horrible. We can live with it. So this is her. I don't know why this is here. I don't know why she's got this editor. She had the same thing last trial. She's testified last trial. But it was determined that there was a case in Maryland that that they did a Daubert hearing on her, and it was determined that she was not credible.
Yeah.
So a different court in a different state determined that her methodology was faulty and that her conclusions were not credible. And so she was barred from from testifying. And so I'm going to speed this up. I'm going to go 1.5 speed, and we'll probably skip a little bit of it. and summarize it. But this is the arguments between the lawyers. The jury is out of the room. I don't think Miss Hyde's in the room either. So this is kind of the arguments. I'm going to grab water. I'll be right back.
All right. Did you want to start it?
Yes, I want to start it because I didn't hit the damn share this tab button. Thank you for reminding me. That's
You're to help.
Yes, you are. Okay. And I got the dogs all excited too.
So
that'll be short-lived.
Yeah.
Half hour.
All right,
Okay, I went to the end of it. Let's go back to the beginning of it, maybe. And get rid of this guy. Come on. Man, I had it right on the spot. Oh, okay. I was at the beginning.
I'm so curious about how he's not sure if he ever attended another autopsy.
Right? I know.
So I want to talk a little bit more about what we talked about at sidebar. And I read the decision from Maryland, just cursory while we were waiting for the witness. And that was a March decision. And I can't stress enough that this should have been brought up before today. So I'll hear you about your concerns, Mr. Alessi. I'll hear the Commonwealth's response, then I'll go finish reading everything else you gave me. So what are your concerns about Jessica Hyde? I don't know if she's Dr. Hyde or what, but I remember she testified the last trial, so you have transcripts.
Understood, Your Honor. I first want to just get the evidentiary basis. This is straightforward judicial notice. There are two separate decisions which require two separate.
One's a Massachusetts case, so that's easy enough.
Okay, so and that's a shall.
It's an SJC case, so yes.
Yes. Okay. So now to the Maryland case. So that's governed by federal, Massachusetts Rule 39A, and that is records of courts of other states or of the United States. The Act provision is the records and judicial proceedings, and of course, the court is a judicial proceeding of a court of another state or of the United States shall be competent evidence in this Commonwealth if authenticated by the attestation of the clerk or other officer who has charge of the records of such court under its seal. So I have with me, Your Honor, that State v. Herrera, Maryland case. I have the certified copy with me from the clerk.
All right, so we can mark that for identification.
Thank you, Your Honor.
Got a certified copy.
Yes.
CC for ID.
Okay, thank you.
So, assuming Your Honor determines that the seal is the seal, it is a mandatory under the rule that it shall be competent evidence, it shall be in evidence. And to the extent the Commonwealth seeks to argue relevancy or materiality, that argument is precluded, Your Honor. And the best evidence of that preclusion is the immediate section below in Rule 39, which is notice of foreign law, which is not this, but it says there, the court shall upon request take judicial notice of the law of the United States or of any state, territory, dependency thereof, or of a foreign country, whenever it shall be material. So the drafters of this rule knew how to put in a qualification or condition when they introduced materiality in B, but they didn't do it in A.
Okay, so focus on what it is you think Jessica Hyde should be prohibited from testifying about.
Oh, Your Honor, I am not seeking to prohibit her from any testimony under this rule. What I want to do is to have it admitted in evidence, have it published, and question her on what she presented to the court in the Maryland case, what was presented, her report, because it was deemed not reliable. And that is what...
On one area, right? One specific area?
Well,
so he wants to, are you catching this?
Oh, yeah. Oh, yeah.
He wants to impeach her testimony, and the rule in Massachusetts says that you shall admit this evidence. Not you may, not that
actually Black's law definition for shall is to be construed as may. If it's something that you have to do or not have to do, they have to use the language must or must not.
Oh, okay.
Yeah.
Huh.
I remember this from the pandemic with Mayor Berkowitz and his, mayoral orders, whatever that we had to do was using the word shall until someone from his law office, I guess, let him know. And then they had changed the language altogether.
Oh, gotcha. Okay.
Yeah.
Well, we'll see that come up in the arguments here in a little bit. Well, not that, but he's thinking shall means shall, like shall means
Right.
you will,
Yeah, like must.
right?
Yeah, but
Exactly.
it's like
Right,
old hat.
This was in the decision, but there's two parts to that decision, two areas. It's FLH frequent location history. But what the court also got at was Apple source codes. That she didn't have the Apple source code.
Nobody in the country has the Apple source codes, right?
Point exactly, Your Honor.
So what is it so you want to put in her report and question her about a proceeding in Maryland? I need to know exactly what you're asking me to allow.
Give you the answer, Your Honor. I won't explain it. It's a very short answer.
Okay.
What I want to do is with regard to her 227 timestamp and her anticipated testimony on that, where she uses a tool, Celebrite, to determine and come to a conclusion about that timestamp. She is not using Apple source code to find out where that's located specifically in the phone and what it means. She is using a surrogate to do that. And I want to cross-examine her on the topic using this decision to say in Maryland, you tried to do the same thing with regard to FLH. You tried to use a surrogate approach and make an opinion about whether that is in fact what's in the phone. She can't do it, and that means her testimony on 227 is not reliable. I'm not looking to exclude it. I'm looking to cross her on her reliability for the conclusions I anticipate she's going to make on 227.
So if she is not asked about that, then what?
Oh, she's not.
That's the funniest part. Like, she's not going to be asked about the 227 search. Like, how is that even a thing?
She's going to bar the defense from asking the question?
Oh, yeah. Well, wait. Oh, just wait.
Not asked about the.
So Brennan gets up. He gets to basically say.
Basis for opinion. It is not a law that is admissible. It's an opinion. It wasn't even about a specific case. It was about a peer review. And so in a Dauber hearing, the court did not allow testimony on significant location. That's not the case here. Try to conflate the argument saying it has something to do with Apple 227. There is absolutely no basis for that argument. They want to say that another court rejected something about you, therefore the jury should reject you. There is no relationship between what she is going to testify as a basis and that opinion. That opinion did not say she was wrong. It said that it was not admissible under Dauber, unrelated. Nobody has the Apple source code. No expert can testify about Apple source code. It's only owned by Apple. And so using the words like surrogate as a way to try to cheapen her testimony in front of the jury. This here, number one.
So he's making arguments that the defense is trying to establish that our witness isn't reliable. Isn't that the defense's job for an expert witness?
Yeah, well.
I mean, one of them is to basically discredit their findings. I mean,
right.
It's what you do to expert witnesses.
What he said, I really can't follow him. I don't understand, other than he's trying to draw some type of relevance to materiality. There's none. This is not a denouncement. She hasn't been found incredible. There's nothing about her methodology that has been rejected by a court. This is on significant location. And although she looked at it, that's not part of this opinion whatsoever. And so because another court didn't allow something under a Dauber, has nothing to do with this case. Nothing.
And what is it that you expect her to testify to, Mr. Brennan, regarding the 207 stamp? We did not have this issue with Mr. Whiffen, right? This was not raised with Mr. Whiffen.
Oh, it was. The 227 timestamp.
No, that was raised, but this, what was problematic and
source codes. And if I could, Mr. Brennan has made a relevance argument. He keeps anticipating my cross, which he has incorrect, by saying it's not relevant. That doesn't go to the admissibility in my cross. I'm entitled to cross her on her reliability. And if I could, Your Honor, in their state Herrera decision, if Your Honor would look at page 3, please, at the bottom of the paragraph, it says, in assessing the reliability of an expert's methodology, I get to do that on cross. It's not limited to a Dauber hearing. Every expert can be crossed on their reliability of their.
So he's saying he gets to do the cross. I'm just kind of going to summarize this here because it does take a while.
Cross-examination.
You can see the plan to dehumanize somebody.
Dehumanize.
So Brennan makes this weird argument, though, that the defense attorney is trying to dehumanize his.
Yep. She's not even a human being like the rest of us.
Right. Which, I mean, just makes, I mean, that's a really weak argument.
To use a term to suggest some type of conclusion that has no basis in fact is an attempt to just dehumanize her and limit her testimony and credibility without any basis in fact.
That's a little bit of that.
Case, it did not deal with the search of a tab and a suspended state in Safari. It didn't deal with the timestamp. It was an entirely different issue. By their analysis, if an expert goes into court on a motion on anything to do with data forensics and the court says that issue is not admissible, they should be impeached when
What
they
are
go talk
explain it?
about a totally different issue in forensic data analysis and another case. They have not shown any evidence that this issue has anything to do with her effort in the timestamp. They just used the word methodology. Her methodology was questioned in an opinion in a different court. Has nothing to do with her opinions here. What information do they have that her methodology in this analysis has been rejected by any court? What evidence do they have that the methodology used in this case is unreliable or improper? They don't have any. In fact, they called an expert themselves in the last case who tried to provide what he believed to be methodology, and they presented that. They proffered that evidence as reliable. No difference.
All right, so he basically goes on that it shouldn't be allowed. He says,
There is, for her methodology, she's claiming a certain conclusion and opinion about the 227. There is no peer review. There is no article that she can cite to support her methodology to come to the conclusion that the 227 timestamp, one, doesn't exist anymore, or two, doesn't mean that the search occurred at 227. That's what she's opined on in her reports pre-trial, and that's what I anticipate she's going to opine on when she takes the stand. I'm entitled to cross her on that. We can't be saddled. It's irrelevant what our witness has said in another proceeding. It's what this witness is going to talk about in.
so same argue. I mean, basically they just argue back and forth. I mean, which is what lawyers seem to do.
Yeah, that's tried and true. I think instead of dehumanize, I think he was saying demonize.
No, he said dehumanize.
He did it? Okay.
Yeah. He used the word because a couple of people had commented on him using that word dehumanize. He did say dehumanize.
Yeah. It might be the second time.
Valid case, and even if
Yep. So back and forth. So the judge eventually goes and they take a long break. Let's see if I can.
But
no good answer for that.
so I will do what I can in the next half hour. I might need more time on this, frankly. But we'll
We're
see.
going to take a
She's
break.
here.
So this is Andrea. So we're watching Andrea Burkhart. I've kind of. Hey, welcome. Good to see you on again. Welcome back.
Hello.
So I've kind of. You can't watch everybody's coverage of 8 hours a day. So I watch Andrea and I watch Emily Baker. Those are two very good attorneys. Andrea they're both criminal attorneys. Emily Baker was a Los Angeles prosecutor, right? She worked for the DA's office in LA before she became a YouTube person. And then Andrea Burkhart still is a practicing attorney. She does a lot of work in appeals in Washington. She's a Washington state attorney. And she's, like I said, she's still active. She still does a lot of appeal work. And so she's more of a defense. If she's doing appeal work, obviously she does a lot of defense work. So here's the ruling. Here is the ruling from
I'm glad to hear that
the
you're on then.
judge.
Thank you so much for that. And thanks for being here from Ireland. Oh, looks like
And then Andrea's
looks like they're coming back.
take of the ruling. And then we'll look at the other.
Please be seated.
The
Close
host would like you to
unmute your microphone. You can.
All right.
Yes.
I appreciate
5.
the time. I appreciate people's patience. So
No, and yeah, that's where I came on too. Like she would go on Rekida's channel a lot, and like during the Johnny Depp, and like you could tell right away she was just really whip smart, really witty. I mean, she was fun. Yeah, no, it's a good 1-2 combo. You get a lot of analysis, especially with Emily. Emily just stops it every 30 seconds, and her thing is, if you want to watch the trial uninterrupted without the analysis, you can go watch the trial. Right? There's plenty of options out there to watch the trial. So she's usually like a half hour, 40 minutes behind the live version of the trial. It's crazy.
in reviewing the rules, I look at rule.
So rule 39 is what Elise said. He was using rule 39, the one that said you shall use this if it's valid testimony. So here's her answer.
So in reviewing the rules, I look at rule 2 So Mass Rule of Criminal Procedure Rule 2, purpose and construction. And so upon reflection and consideration, it says these rules are intended to provide for the just determination of every criminal proceeding. They shall be construed to secure simplicity in procedure, fairness in administration, and the elimination of expense and delay. Also looking to Commonwealth versus Durand. I don't have the site. I know it's from 2016, 2017. A judge, Robert Kane, was the trial judge. So because none of the purposes here in Rule 2 are served by the admission of the Maryland trial judge's decision, particularly where offered without notice to the court previously, I'm excluding that decision. Your rights are saved, Mr. Alessi. We've got that decision marked for identification, and you certainly are free to cross-examine Ms. Hyde regarding her methodology. So that's my decision.
So you can't reference the Maryland trial at all.
So
she had to go look for other stuff to try to justify, and she literally relies on the policy statement. That's weak. That is very weak.
Chrissy, do you want this under
specific
that?
rule will control over a go look for other stuff to try to justify, and she literally relies on.
That's my decision. So
she had to go look for other stuff to try to justify, and she literally relies on the policy statement. That's weak. That is very weak.
Chrissy, do you want this under that?
The specific rule will control over a general rule that talks about the same thing. That's one of the principles of statutory construction, the specific general rule. There is a specific rule that he cited that's dealing with the admission of records from other courts. That is going to control over how generally should we interpret and apply these rules as a matter of policy. This is like a statement of policy. Like, yeah, trials should be efficient. And but that fairness part, are you reading that out? Reading that out of the rule? The specific rule is generally going to be the one that applies over the general over the general one. So if the general one says maybe, maybe not, but a specific one says yes, then the answer is yes. But the fact that she had to go do her own independent research to try to find a reason to keep this out, it just shows you the incentive, the motive. She had to go look for a reason to keep it out. She wants to keep it out.
So that was, basically, and then, she's saying that the specific rule, the Rule 39, should take precedent over the Rule 2. Is one of her big arguments on it. And I don't know, what do you think? Are you there? I can't hear you. I have no idea what's going on. Look on the we're having a moment here. Just stand by, please. It's a USB-C. If the mic came unplugged, it's a USB-C cord. Nope. So look on. Okay, so go to the Wave software. You might have to click on the little side. There's a little arrow on the side, and then you need to open up the WaveLink software is what you're looking for. It's in the little control menu on the side. It's probably not open. Or you can go to the menu and open up the WaveLink software, and then there should be you should see your mic on there, and then it should be red if it's muted. And you can unmute it there. Oh, I see you unmuted there. You were muted for a second and then you unmuted. Is the light still red? Okay, yeah, it's in the WaveLink software. It's in the microphone software. You have to open up the WaveLink software. Here, look, let me share my whole screen. Sorry, guys, bear with us just for 1 second. Okay, if you look at my screen here, down here in the corner, there's a little program area. There's a little like caret or a little up and down thing. And then when you open that up, there's a bunch of little icons there. Find the one that says wavelength. It's got like little lines. And then double click on that.
How's that? Am I back? Am I back?
You are back.
Don't know what happened there.
Yeah, that's weird. Yeah, it wouldn't be a stream of ours if there wasn't freaking technical difficulties. But yeah, no, that's how you do that. If your mic goes red like that again, that's where it's at.
Okay.
All right.
So what were we talking about?
The argument here. Yeah. So basically, that the rule, the 39 rule, the more specific rule, should reign over the general rule of how to
right
run the case. Does that make sense?
Yeah, and the judge just decided to ignore that.
Yes. Yeah, completely. So, okay, so I got it queued up here and somewhere. Let me find it here. So
as they approach, hold on, let's see if we can zoom past. No, let's not zoom past. Let's kind of take a break and explain what's going on. It seems that the Commonwealth's next expert is
okay. So
with the WebEx nonsense.
The time, I appreciate people's patience. So, in reviewing the rules, I look at Rule 2. So, Mass Rule of Criminal Procedure, Rule 2. Purpose and construction. And so upon reflection and consideration, it says these rules are intended to provide for the just determination of every criminal proceeding. They shall be construed to secure simplicity in procedure, fairness in administration, and the elimination of expense and delay. Also looking to Commonwealth versus Durand. I don't have the site. I know it's from 2016, 2017.
Is that in the annotations?
Robert Kane was the trial judge.
Yep.
So because none of the purposes here in Rule 2 are served by the admission of the Maryland trial judge's decision, particularly were offered without notice to the court previously, I'm excluding that decision. Your rights are saved, Mr. Alessi. We've got that decision.
So basically, she's saying your rights to appeal this if something happens are preserved because you've made this argument, right?
Marked for identity.
But as the saying goes, appeals are for losers, right?
Mm-hmm.
If you're appealing a case, it means you lost the case.
And you certainly are free to cross-examine Ms. Hyde regarding her methodology.
That makes sense.
That's my decision. So bring the jurors in, please.
Okay.
You are unmuted.
That's
Chrissy, do you want this under that?
Actually what I thought was going to happen. So, and I think that's the appropriate ruling. The ruling itself, just so we're clear, the ruling itself is not going to come in. I don't think the ruling is proper evidence. The stamped copy of the text of the ruling is not coming in. I agree. I don't think it's proper. But he can question on cross-examination about it, which is really what he wants to do anyway.
And I think she got that wrong because he's not allowed to actually cross-examine on it. So
that's really the heart of the thing. He can ask her about it on cross-examination. The jury cannot read the ruling from another case. Why? It's just going to confuse the jury. It's not proper evidence. I don't disagree. So he gets to ask about it on cross. I think that's the fair and proper result. And if the court had had more time, I think you would still get to that result. And I also think that.
So it sounds like she's a little bit confused on what the ruling was, right? Like, and you'll see when we get to cross-examination. So, but it's just kind of funny that she's I mean, in this trial, she sees the crap that's gone on, but she also calls it like down the middle, right? Like she tries to see it from both sides, and
balls and strikes here.
And I think having a more prosecutorial background probably colors some of her analysis, right? You would.
Yeah, maybe not. I've worked with a couple attorneys. They can like switch it on and off easy enough. I'm prosecutor.
Exactly.
I'm a defense. Yeah,
All right. So then we get into the actual testimony of Miss Hyde. I'm just gonna play some of it, and then you tell me if you understand what she's saying. Okay? I'm just gonna pick a spot. All right, and we'll start here. And let me share the tab I'm in.
By the purpose of the exam.
Were you asked to look at the phone device and determine whether or not there were any user-initiated deletions of phone calls on the device?
Yes, I was asked to look for deletions of phone calls in that same date range.
And did you do both of those tasks?
Yes, that's correct.
Do you ultimately have opinions on both of those issues?
I do have opinions on both of those issues. That's correct.
Oh, she's got opinions. All right.
Hey, what's up?
The integrity of the data. That
Trying
you
an
were
experiment. I'm still streaming on my channel.
Forensic image. The first thing I did was I did what's called a hash of the image.
See if I'm going to confuse the heck out of my audience. They're seeing two images of me.
Presentation of a file. So a forensic image,
I don't think I can stop that. If I turn off the camera, it turns off.
File that can be extracted and have the rest of the data. That singular
my audience
file
sent me here for the fat shaming.
There's actually 3, but focusing on the one that has all of the data.
All right, I'm gonna skip to a different one. I hadn't watched that, so
yeah.
Bear with me here for a second. I think we can. All right, so
we're here for our dialogue, not his.
Yep.
I'm sorry. Can you repeat the question? I got this. Hi.
All right, so
A reseller of Mac continued to consult for them for an additional 2 years under my company Hexordia, and my company continues to be a reseller of Magnet's products.
You mentioned different tools may present information a different way. 40 timestamp.
Okay.
The next recording on that tab, do you recall what time that was?
I believe the next, and I'm trying to remember the chart from memory, if that's correct. So I believe the next thing we're looking at is the 623 suggestion from Apple search terms for how long to digest food. Am I matching what you're seeing on your chart?
Well, let me ask you.
Okay.
When you saw that, do you look on the same tab or a database? Where do you find that information?
Fair. Understood. So all of those databases I was just mentioning before, we're looking at all the parsed results from all of those. And I was looking in the entirety of the scope from the time of midnight till noon. That was the time frame of my scope of all of the content that was done in the tabs, the tabs for browser state DB, cloud tabs, artifacts, history DB, mobile Safari plist, knowledge C, each one of those. And then I was combining them to timeline out the activity.
At 6:23:51.
So obviously she's pretty smart, right? She's a smart woman.
Right.
She knows her stuff. But I mean, it's hard to get that off to a jury.
Can they appear in different rooms in the data bank in different places? The same search?
Searches appear in many different places. They can leave traces, such as that knowledge CDB. I love that Apple calls that knowledge. It's like what it's trying to learn. So the knowledge CDB, what Apple's trying to learn about you, as well as in that mobile Safari plist, as well as at the moment of that search, which I don't have the device in that moment, but just so there's an understanding, that open tab, the URL would have been updated, or URL is the website, would have been updated to that search at that moment. Had we imaged it at that moment, it would have been how long to die in CIKD.
And finally, at 6:24:47, did you identify?
So I mean, this is
long to die in cold was actually searched at 2:27 a.m. on January 29, 2022.
There are no artifacts.
So the answer is yes or no?
Can you repeat the question, please?
And so based on your analysis of the phone and the data using all of those softwares, did you come to an opinion whether or not the phrase "How's long to dying cold" was searched at that timestamp tab of 2:27:40?
Yes, I came to an opinion.
And what is your opinion?
Objection, Your Honor.
Rephrase the question as to the opinion.
I'm sorry?
I'll see you at sidebar, Mr. Leslie.
Your Honor.
All right, so we get a sidebar. Sidebars come into play too. So, okay, so we go back.
Marcia doesn't think that the search jurors are taking relative. Sorry, emergency with a kid.
Working group of digital evidence.
In addition to what you did, can you?
So then he goes back. So then he's got to lay more foundation for this.
Share with us.
He can't just like give her opinion.
How and why this methodology is accepted in your practice as forensic analyst.
This methodology is accepted by NIST and by organizations like the Scientific Working Group of Digital Evidence. I'm intimately familiar as both a member of the Scientific Working Group on Digital Evidence, who helps work towards the building and development of these consensus-based documents of procedures to be followed in digital forensics analysis, and as a member of the National Institute of Science and
All right, so now we get on, and then he asked her to
Anderson's
just
because that was alpha. So when a SQLite database, which is a specific way of storing, very, very common on mobile phones, actually one of the most common, when that database stores data, it has two versions. The most recent version, and the version in use here, uses what's called a write-ahead log. So before data is committed, it is written to a write-ahead log. I'll kind of explain it. So let's say we're in a restaurant.
Here we go. See if this helps you understand what the hell she's talking about.
And we're sitting at a table and we're ordering food. Our table is the table. Data is going to come to the table, and that's going to be our food. So when we order food, let's say we've got a chicken sandwich, a burger, and a pizza coming to the table.
Oh, and we're all
The
hungry.
chicken sandwich, the burger, and the pizza, the kitchen puts it in the warming area. It's the write-ahead log. The server grabs it from there. It's where data sits before it goes to the table. Just like your food goes to that serving station before your server brings it to your table. Server brings it to the table. That table's got its burger, its chicken, and its pizza. Another table orders waffles and pancakes. They think it's breakfast. The waffles and pancakes are made by the kitchen. They're put on the serving area. Waitress comes up.
Are you following this?
I got this. Yeah. It makes almost sense.
Over.
Almost.
This pizza has pepperoni. I don't eat pepperoni. Can you send it back? Waitress picks up that pepperoni and sends it back. That's a deletion. Pepperoni pizza was just removed from the table, right?
The pepperoni pizza was just deleted, Michael.
From
That's
the table.
A deletion from the table.
We're deleting it, removing. We said it's not what we wanted. The waitress is removing it. She brings
But
it back
not
to that
from the
serving
server
area.
station.
At that moment, that serving area has the deleted pizza, but also the waffles and pancakes that are waiting to go out to the table.
So the server warming station has the deleted pizza and the pancakes and the waffles.
Right.
That's how a write-ahead log works. Any changes that are happening sit in the write-ahead log until the database is closed, and then when it's reopened, all those changes are made, both additions and deletions. So
No,
often when a phone is
she lost me.
imaged, when we
She lost me.
Right?
make a forensic
I was
image,
following the
the
analogies for, but then she just says, and that's how it works.
serving area. At that moment, that serving area has the deleted pizza, but also the waffles and pancakes that are waiting to go out to the table. That's how a write-ahead log works. Any changes that are happening sit in the write-ahead log until the database is closed, and then when it's reopened, all those changes are made, both additions and
Yeah, so what happens to the pizza when you close it and reopen it, right? I mean, do you shut the pizza and then reopen the pizza and then
Yeah, I don't think. Yeah, she skipped a step.
Yeah, exactly. So
burger, right? Pizza got sent
then
going
we
to that
keep
table, so it
going.
shows it as if it's in the table, but it's not in the table yet. So if when we parse the data and we look at the restaurant and we don't look at the back kitchen, we would only at that time see the chicken and the burger, right? Pizza got sent back, waffles and pancakes haven't come out yet. So when we get the data, we get two files. We get the restaurant, that's the database, and we get the serving area, that's the wall file.
Now, if you look at Brandy you're on the left.
Just because it's a wall file does not mean it's deleted.
What is going on?
It means that record wasn't where it naturally sits yet. It could be that wall file can contain deleteds and food or data that hasn't yet been delivered to the database.
Oh
So the
my
wall file consists of both. So an assumption that the data was deleted just because it's in the wall file is actually not true. And the peer review paper I mentioned earlier that I had accepted in Forensic Science International actually has a section that explains its exact presence for SQLite databases about how we refer to that as recovered.
So, I mean, just this jury's got to be lost with this. I mean, just absolutely freaking lost, right?
Yep.
Just like, what the heck are you talking about? So there was another moment, though. There's all kinds of moments.
Hopefully the testimony's after lunch.
Oh. Yeah, you're talking about the pizza and the burgers and the fries and the
pancakes.
Pancakes and waffles. Okay, so basically, during this time, they're objecting and they want to have their argument made. The judge does not allow you to make
That's correct.
Now, I want to ask you, to a reasonable degree of forensic data, scientific certainty, what is your opinion about whether the phrase "how's long to die in cold" was made at the time?
So he is asking her for her opinion on that.
Of the timestamp 22740.
It's the last time Mr. President on this issue, okay?
This is the last time on this issue, Mr. Alessi. That's the comment from the judge. How's that for impartiality? Like, you are bugging me now, Mr. Defense Attorney.
Yeah, it's getting old, Mr. Attorney.
Yeah.
It's the last time Mr. President on this issue, okay?
You can hear it in her voice too. It wasn't just a normal thing. It was you're bugging me.
Yep.
Last time, that's a nice little comment there from the judge. That's inappropriate. That's inappropriate. That's putting your thumb on the scale there right in front of the jury. Last time, Mr. Alessi.
Yeah.
Bev is she done okay with me the first couple days of this week. But now she's reverting back into her putting the thumb on the scale.
Yeah, but she does come back and say, let's see what we got here. So this is right after lunch, right before the cross-examination.
Yes. Are you sharing?
Damn it. No, thank you. God damn it. All right. This is what she said.
No, I think I told you in the beginning, one of my functions is to make sure that a case is tried fairly and efficiently and not to waste anybody's time. So if I get frustrated at lawyers about something, I try not to, and I don't think I can, but if I seem to cut somebody short, the lawyers are just doing their job. When they request sidebar conferences, they're just doing the job. I am going to try and keep all sidebar conferences to a minimum, but the lawyers are just doing their job. Okay.
So
right,
that's like the best apology you're going to get from this judge, right? Like,
yeah.
I know I kind of screwed up, but it's the lawyer. It really is the lawyers, because they are a frustrating bunch of little goofballs.
In my defense, they were frustrating me.
Yeah, right. Exactly. It's like, I want to keep this thing moving, and they have all these legal arguments that they want to make. I mean, what the hell?
I mean, just imagine how this guy is at home.
Yeah. So we get into cross-examination, and to be honest, I did not look at I want to see what Emily said when we started the cross-examination, because he gets shut down immediately because he tries to bring up that
Maryland bit.
thing. Yeah, exactly. So okay, so here we go.
Share.
Thank you. God damn it. keep forgetting that.
And you recall on your direct examination, Attorney Brennan asked you questions going to your experience and qualifications. Do you recall those questions?
Yes, I do.
You were involved in a case, is actually a murder trial in the state of Maryland.
We're getting right into
called
it.
State v. Herrera, as recently as March of 2025, correct?
Correction, it's an attempted murder.
Attempted murder. And
boy.
in that particular case, you had attempted to offer various opinions to the court, correct?
I object.
You have to move along from this case, from what you're talking about. You have to move around.
So, okay. Now it's clear. She thought she was going to allow him to cross-examine on it, but obviously she's not, because she just said, nope, you got to move on from that case.
Along from that Maryland case.
So with regard,
what?
Do you recall another?
You said he could cross-examine about it. I think the way to cross-examine about it, and we'll see if he goes back around. I think the way to cross-examine about it is, you've given opinions in other cases, right? How many? You've given opinions about the tabs. You've given opinions about times. You've given opinions about this, and get into the nature of opinions she's been.
But no, he never is allowed to get into the Maryland case.
Right, but you submitted a pro se amicus. Do you recall that case?
I do.
Oh, and what's the lippy?
Is it correct that in that case,
Emily riveting
you
legal commentary?
submitted,
Yeah, but we want to know.
Argument.
So yeah, so he does do a good job though of like beat the crap out of her entire thing. Basically points out a whole bunch of
When there is again Apple Health data,
statements from her past testimony where she said, where she just basically said she didn't know. She has changed her testimony quite a few times. Celebrate, if you saw any of the other experts, Celebrate actually changed their software to delete that 227 search artifact, right? Did you know that?
No, but they update all the time, so.
Right, but they specifically deleted that search artifact for this case.
Oh.
Yes.
Mm-hmm.
Yeah. No, it's crazy. Let's see if this is it.
Ms. Hyde, if I could draw your attention to the entry that is, it says.
Just to orient, because I've paused as I'm going to data.
All right.
She is saying delete.
Pauses here. But he does a really good job though of freaking smacking her down.
Do you think the defense has their own electronics forensics expert that they're going to put on?
Oh, yes. Yes, they do. And then one of the other things to highlight is some specific wording that Brennan used on that they kept using something called user deleted, right?
Right. That means I deleted it and the phone computer didn't yet.
Yes. So.
And the computer doesn't really delete, it just writes over.
Yeah, correct. And she said it at like one night, for phone calls, it says that the Apple only holds like 300 phone calls, and so when you get to 301, it'll start, it'll go to 299. It'll start deleting all those calls, right? So, but they use the term user deleted a bunch here.
All right. Are you sharing?
No.
To die in cold.
Scientific certainty, whether or not arrive at an opinion to a reasonable degree of scientific certainty.
Keep jumping around.
Whether or not the user deleted the phrase "How long to die in cold."
Yes, if it's how's long to die in cold. Sorry, trying to clarify.
Pardon me. Did you come to an opinion to a reasonable degree of scientific certainty whether any user deleted the phrase "How long to die in cold"?
Yes.
And what is your opinion?
My opinion is there was no deletion that occurred by the user because it is not something a user can delete.
It's not something a user can delete. It's not somebody that that there's no function to delete a search in a phone if you're a user. Okay.
Okay. Can't just clear your browser history.
What do you think, Matt McCabe, Jennifer McCabe's husband? Do you know what he does for a living?
I bet he's an IT guy.
Well, what do you know? He is the CEO of Elevate Technical Solutions.
Interesting.
Which does cybersecurity, data and analytics, enterprise infrastructure and cloud enablement, program and project management, software development. Do you think maybe there's a reason they keep saying user deleted? Like there's no function for a user to delete something. But what about a technical expert in the field of, IT and stuff? Do you think maybe that person could possibly? In 2009, brothers Michael McCabe of Sandwich, he's from Sandwich, and Matt McCabe of Canton partnered with former Higman residents, blah, 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 to find Elevate Technical Solutions. So, yeah, just so happens Mr. McCabe is somewhat of a
twidget.
Of an IT person or expert, or at least he owns a company that does this stuff. So I think it's maybe possible. This was a story from 2014. Canton Mental Health's partnership grow at the speed of cyberspace technology. And there's Mr. McCabe right there in the back. Makes you wonder, doesn't it?
The plot thins.
All right, and then so then we go through this whole 227 search, right? This whole day is mostly about Jennifer McCabe's phone, right?
Right.
And then, we get she does bring up the it's funny. So at the end, she does bring up a little cool thing here. So. She had to throw in a little Star Wars.
You're not sharing.
Damn it. I quit. All right, here you go.
Is that in May of 2023?
May of 2023.
And you said it was in May working on analyzing phones in this case, and you said it was in May. Was that of May of 2023?
May of 2023, May 4th, 2023 is the email I have of a note. Thank you. Yes. It's easy to remember because May the 4th be with you.
When you first were asked.
Nice that she had to slip that in, huh?
Yes.
To begin work on this case in May of 2023.
Right. So we get through all of that. This whole day is about Jen McCabe and her cell phone and her
correct,
her thing.
Is using a different
little bit of
Brennan
cross here,
and you referred to Axiom as using a different parlance of with the timestamp of carved, correct?
Celebrite uses this deleted demarcation or recovered demarcation. Axiom does not do that at all. They speak to how they recovered the artifact, be it that it was parsed when
I don't think the jury's got to be just like side-eyed by this, right?
say parse,
I would not even be awake.
Yeah.
The item.
Her explanation is, and if I'm summarizing it correctly, at the end of this day, parsed is you found the artifact where you expect it to be. Carved is you find the artifact where not where you expect it to be, elsewhere.
From
everyone's making it a big deal, but I don't know if the Celebrite thing is a big deal.
Yeah, they also talk so in a murder case or in any case, when you have a cell phone that you recover that you want to do that's part of a case. What is the first thing that a normal investigator would do if they get a cell phone from a person that they want to use as evidence? What's the first steps you do when you get that cell phone?
Get a warrant for the information.
Right. But actually with the cell phone, what would you do technically to the cell phone to preserve that cell phone?
Copy it.
Even before that, when you first get the phone in your hand, like you put it in airplane mode, right? So you can stop any more data from coming into the phone, right?
Okay, sure.
And then Stephen mentioned putting it in a Faraday bag, so it really can't get any more information.
For the phone of Mr. O'Keefe, can you think of any other reason why that phone wouldn't be put in airplane mode, Faraday bag, or Faraday box?
Best practice would be to put it in a Faraday bag.
Okay.
So she does get into some of that best practice stuff, which,
But they used a brown paper bag instead.
Yeah, right. And they didn't put it into airplane mode because she even says that throughout the morning it's getting ring data come in, it's getting text messages coming in, right? Like there is basically still activity going on that phone until she didn't go past noon because that's all she was told to look at. But who knows how long?
It's not in airplane mode.
Keeps
It's not in a
over-talking
Faraday bag, and it's not a Faraday box. Correct?
Unless it was in a broken Faraday bag, like they put it and it was
keeps
it does not appear to have been placed in Faraday bag.
All right.
So we get through all that. Then at the very, very end of the day, for some reason, we get another freaking recording or clip played. Like right at the end of the day, we get to see a movie to go out.
15, please.
Clip. He's starting to sound like Dorinda. Clip. You guys will have to let me know how you interpret these clips. I think some of it's going to come down to how much you know about this case and not. It's hard to evaluate these clips in a vacuum. Katrina Bunny, that is a great question. Hold on, let me go. They are her words. Whether it was hopefully that helps. Oh, this is from the ID series. Let's see what clip 15.
Either I'm going down, Jen, or you.
This was the clip they played at the end of the day.
Absolutely love Jen McCabe. Jen McCabe, it's me or her. Either I'm going down, Jen, or you are.
That was it. That was the whole entirety of the clip they played at the end.
What was the point of that? From a legal standpoint, from a court proceeding standpoint, I mean, that was...
Why?
Yeah, I need more context to that sentence.
Yep, that's it. That's all they played. So realize Jim McCabe has already testified, right?
Mm-hmm.
She spent 2 days on the stand. You've had two witnesses, the two experts that you've seen in this case so far have been talking about Jim McCabe's cell phone, right? That's the two experts you've had.
Right.
You've had other questions about Jen McCabe, like the Carrie Roberts thing. A lot of her testimony was about Jen McCabe, right? So basically what you've done with this clip is you've now put, because a lot of this case has already been about Jen McCabe, it's like you have now with this clip said, jury, do you think Jen McCabe is credible or do you think the defense is credible? Right? That's basically what you've done with this clip. I mean, it's weird. It's weird.
Absolutely love Jen McCabe. Jen McCabe, it's me or her. Either I'm going down, Jen, or you are.
And that's it. So you basically just told the jury to decide who they think is more credible. It's
and Jim McCabe's not sitting in the defendant chair.
Correct. Right.
So it's not her or Jen. It's because Jen's not going down no matter what.
Mm-hmm. No, exactly. I mean, you've got the testimony. Remember the testimony about the FBI showing up and her lying to the FBI. I mean, it came in that she lied to the FBI, which, you know, they weren't allowed to say FBI, but they definitely said,
How is
said
that,
agents enough.
How is mentioning that they are employed by the FBI tainting the jury somehow?
That's another
instead
one
of
of the
leaving them
rulings, dude.
instead of leaving them listed as some like ghostly kind of behind the shadows Big Brother type government agency.
Yes. Right.
You know, how am I going to know some unnamed agency is credible versus an agency that I've heard of my entire life?
Yep. Well, in the first trial, when the ARCA witnesses testified and they said that they were, they weren't hired by the defense and they weren't hired by the prosecution, right? It came out in the jurors that agreed to be interviewed by different folks. It came out that they were very confused about what that meant. And it was assumed by quite a few of them that it was actually Karen Reed's insurance company who hired ARCA to do the testing. That's what colored. So imagine that coloring the thoughts of the jury that they think it's an insurance company that hired these experts and not the federal government, because it wasn't even allowed to get in that it was the federal government. So, and it's the same ruling for this. Does it make any sense? No, it's another one of these things that could easily be appealed after the fact. I mean, it's nuts.
Yeah.
And then, yes, you are correct. So Jess Mikado is not going to be in the courtroom next week, but she does a very good job. And I'm sharing the tab. I am sharing. She does a really good job of like watching the jury and kind of describing the jury of what's going on. And, basically that, just reporting on what's going on in the courtroom. And just how some of the jurors are reacting, right? Like they're going back and forth. There's jurors that are just like that take notes nonstop. Let's see if I can find. I'm looking for one here. Let's see. Hyde is now explaining the Haas long to die in cold search was in a tab along with another tab in the background. With the It's Raining Men video. Right now, 8 jurors are looking directly at Hyde. The rest are writing in their notebooks. They all seem in one way interested in this testimony. And then there's one juror, I guess, that's like very uninterested in most of the trial. But today, that juror's actually been one of the most interested in the trial. So
interesting.
Yeah, right. Oh, and then so I guess in some of those so Bev and Alessi are going at it on the sidebar that he called for. He has a pen in his hand and he was pointing it as he spoke. I can hear her say this is the last time she's allowing a sidebar on this issue. I'm not going to report on everything I can hear, but Alessi's extremely passionate right now. What do you think that's kind of code word for something, right? Passionate?
Well, I've seen in court before where an attorney gets he doesn't prevail on something that he knows he should prevail on. And in this one specific case, when that attorney left that courtroom, he could have shot lasers out of his eyes. He was so mad.
Oh, yeah.
Because it was like one of those simple things, like this is res judicata. There's no way around it. It's right here, black and white. And the judge decided, no, that doesn't apply this time. Why not?
So, yeah, now one juror reacted to testimony of Hyde saying that her opinion is the house long to die in cold search actually took place in the morning and not at night. Hyde is explaining how food at a restaurant is served and how it can be like how data's on the phone. And Karen just had to control a laugh. She covered her mouth to lean over to Yannetti. Waffles and pancakes, bread and peanut butter. Note taker looks confused with what is being said. They pause note taking to look down at Hyde during her testimony. So, yeah, I mean, it sounds like they were interested at first, and then a lot of them just kind of fell off because
it's lunchtime.
That was
before
lunchtime, and you're listening to it was actually the waffles and pizza and all that was before lunch. So let's see. Smirky juror enters the chat when Alessi was getting Hyde to admit on the stand that she had Whiffin's artifact with all the other data. Smirky juror smirks and takes a note. There was a point where basically she had put in her report that at this certain time was the last interaction that anybody had with the phone. But then the other expert put in there 12 minutes later that somebody pushed the button to lock the phone, right? So that would be an interaction with the phone that she missed. And so there was quite a bit of back and forth on that. Let's see if I can find that.
Share.
Yeah, I will. Yeah, I
That's
will.
a preemptive share.
Yes, no, I appreciate it.
Interaction when it comes to that.
An additional 20 seconds.
Isn't the more correct way to state the conclusion that the active interaction when it comes to steps is not calibrating using the screen, but the phone is calculating steps taken. Isn't that correct?
That is correct, but that's not interactivity with the device.
I understand.
All right, let me see if I can find
Now,
I concur.
so that means that that interaction with the phone occurred at 12:32:09, correct?
I did not review that specific artifact. I cannot attest to Mr. Whitten's exam, only to my own.
So do you have any reason to believe that what is in evidence in this case that Mr. Whiffen has produced, and that do you have any basis to contest the fact that the device was locked with a lock button for the last time on the phone of John O'Keefe at 12:32:09 as you sit here?
I cannot contest it because I do not recall looking at that specific artifact.
Don't you think it would have been appropriate to be accurate as a digital forensic analyzer on the topic of the last of an indication of interaction with the device? Don't you think it would have been appropriate to look at that 12:32:09 in any of the tools you said you used on direct?
I did not correlate that artifact in my timeline.
I understand you didn't, and my question is, you make a statement. Well, let me back up. Do you understand that in this case, as in many cases, that matters of seconds in activity can be determinative of a case? Do you understand that from your experience?
Absolutely.
So it's important, therefore, to get activity right for any data forensic examiner when they're issuing reports about activity, particularly of a decedent. Is that important?
Absolutely.
So isn't it correct that the statement that you make on page 7 of your report, that from that point, 12/20/50, there is no indication of interaction with the device, is incorrect?
I cannot make that without going back and reviewing and validating the artifact you just produced from Mr. Whiffen. I would need to validate that in order to respond to that.
But as you sit here, you have no basis to contest what Mr. Whiffen has stated, that there was a lock button on the side of the phone of Mr. O'Keefe a full 12 minutes after you say there was no interaction with the device. Is that correct?
I don't. I would have to review that portion.
You said it was
Is there
the last.
anything that had prevented you
How
from
come you didn't see
reviewing
it?
that in that data before you wrote this report?
Yeah.
Not that I can think of. I would have to go and re-review that.
My question is,
I don't know if that artifact, I have not reviewed that artifact. So I
frustrated.
cannot
She doesn't
speak
like being
to an
wrong.
artifact I have not reviewed, and I did not, that is not my report, that's Mr. Whiffen's report. So I cannot speak to that without going back and reviewing that evidence.
isn't the
You made a
interaction
claim, you
device
can't
lock
back up.
button readily available to you in the data that you have and had in your possession when you wrote this report?
Yes.
Thank you.
That last part. Isn't the data that he had the same data that you had? Yes.
Was it really?
Well, yeah, that's the thing. Was there different data for somebody else? I don't know.
Maybe that IT guy?
Yeah, right? Maybe good old Matt McCabe. Oh my goodness. So yeah, just kind of,
Yeah.
So, I mean, quite a bit of legal action today. I mean, I think for the jury, it was quite a lot of freaking, what the hell is this woman saying?
Right.
I mean, I don't know how any of this shows that John O'Keefe was hit by a car from his girlfriend, right?
Right.
Does any of this get us in? And this is an entire day of trial. Does this get us any closer to the dude was hit by a car?
You would think so. But
You would
no.
think that's what they'd want to show, right? You would think that is the kind
The
of
particulars of the
information that-
crime?
Yeah, that was the kind of thing that the Commonwealth would like to prove, that John O'Keefe was hit by a car. It's kind of important, I would think, to the whole thing. So yeah, tomorrow is supposed to be Trooper Buchanan. We'll see how that goes. We could see another crazy day. So the one thing that's completely not related to this case was UW yesterday or 2 days ago. It was 2 days ago. They had a bunch of protesters break into their engineering building at the University of Washington, right?
Yep.
Did you see this?
I saw part of it, but it was just.
So this is, scrolling. Scrolling. This thing right here. This is a tool lathe. See if this shows it. So yeah, this was the fire that they set outside the building.
Peaceful protest.
Yep. Right. So there's that, and then this lathe is a Haas. I thought there was a video of it, but this is like a $35,000 tool lathe for the engineering department of UW that is completely destroyed. Right. Among many other things, right? It's not just this, but this is one of the things that these people just completely destroyed. They did over $1 million worth of damage to the engineering building.
And it benefits their argument how?
Right? Like this is going to be how, this is going to get people to come to your thing. Oh, there we go. There's some more of the thing. That's one of the offices. They, dude, this was planned. Look at that. They brought food. They had tools. They had a tactical playbook, which, is just, they're not the brightest freaking people, but
you got to have a checklist.
Yep. They had the checklist of what they wanted to do. And I love that it's in a little flip book, but you still got a map, right?
Right.
And then, rooms, like they're planning, like you look at sleep rooms, dude. A quiet room, a sanctuary.
Cute little flower picture.
A rage room.
A very poorly drawn cube.
Yeah. What the hell is even that? It's backwards. So yeah, their goal was to have UW divest from Israel and Boeing. This is a Boeing thing, right?
Right.
Of course, they had coloring books because you don't do a protest without your coloring books.
You gotta have the children.
Yeah. So the craziest thing. So all this damage, $1 million worth of damage. They're not going to be able to open this building up for the rest of the year, right?
Right.
So the school paper. What the hell is it? Come on. This guy writes too much. Where the hell is it? It was freaking on here. $1 million plus in damages. And then the school. Okay, yeah. The school newspaper called it a Boeing sit-in. Yep. The University of Washington school newspaper called the Antifa hijacking in the engineering building an anti-Boeing sit-in. They don't mention the $1 million in damage, the break-in, the law enforcement resources that had to be used to get them all out. Nope, they call it dozens of UW pro-Palestinian protesters arrested at anti-Boeing sit-in.
Because Palestinians give two shits about Bell Boeing.
Yeah.
Okay, yeah, sure.
Yeah, I mean, the school did come out and say that, this was no peaceful protest in support of Palestinian rights or against the war in Gaza. I condemn this dangerous, violent, and illegal building occupation. But of course, they didn't stop them from going in there. As Andy here says, it doesn't mention who was involved in the attack. So, yeah, I just thought that was interesting how.
Yep.
The narrative that you get too. It's all about freaking narrative.
Yep.
Like, this is a Washington state rep. I've gotten confirmation from Super UW that the arrested protesters have all been released. If they need additional support, I'll do my best to amplify how we may be able to help. If this is a Washington state representative that's saying that they're going to support the people that did $1 million worth of damage to the engineering building of UW, is there? I mean, I know Washington's pretty much gone anyway. It's pretty much a basket case, but I mean, what the crap, dude?
Yeah, it's like, I know not all of Oregon is, has Portland carrying their flag for them, but
right.
I'm pretty sure all of Washington has Seattle being their torchbearer.
Spokane area is not as bad. If you've ever been over to Spokane, it's not horrible. It's a lot different than once you get across the mountains. It's different. Now, the Spokane, Coeur d'Alene, Idaho area, that's probably the strongest. The middle of Washington is one, it's like a lot of just agricultural areas. There's not a lot of people anyway, but yeah, nutty.
Yeah.
Nutty stuff, man. It's just crazy. So, all right. Well, that's all I got tonight. Why don't you go home and get some rest, and then
we'll try this another day.
Yeah, you up for tomorrow?
Hard to say.
What's your schedule look like tomorrow?
Hard to say.
I'll come into the. Okay. Well, I'll come by
another
the shop
game time
tomorrow.
decision, I'm sure.
Okay. Well, I'll set up at the shop tomorrow, but this worked out pretty well, I think.
Yeah, I could see that.
You there, me at home. I think that worked pretty good.
We got through it easy enough.
Yeah. If I would remember to share my damn screen, I'm glad you're here to tell me, hey, share your damn screen, Rob. Share your screen.
I'm supposed to be watching something here. I don't know what to.
Yeah, exactly. All right.
All right.
Well, I will see you tomorrow.
Talk to you then.